Okay, let's try this again. Fantastic. So, welcome to that red and blue podcast where there's audio now working. Fantastic. So, what we're going to be looking at is if Joe Biden's choice to pardon or not to pardon, in this case, pardon, was appropriate for the actions that Hunter Biden had done. So, with any case, when it comes to research, which I enjoy, it's important to go to the primary sources of information. In this case, Joe Biden himself. And here, where we're going to start, is with his statement from him, maybe not written from him, but from him nonetheless, from the White House. So, here we go. So, this is quoting the document. The items on the right of this document are my serious notes. The ones on the left are me being that little voice in the back of your head saying all the things and thinking all the things that you want to say. All right. Today I signed a pardon for my son Hunter. From the day I took office, I said I would not interfere with the Justice Department's decision making, and I kept my word even as I have watched my son being selectively and unfairly prosecuted. So we see one of his first claims, unjust treatment. And the reason why I'm making notes of this is to be able to determine if his claims are just or not. We need to know them so then we can analyze them, look at if there's evidence supporting them or not supporting them, and come to a reasonable decision. An informed opinion is important, one that is not often had. I have watched my son selectively and unfairly prosecuted. Without aggravating factors like use in a crime, multiple purchases, or buying a weapon as a straw purchaser, people are almost never brought to trial on felony charges solely for how they filled out a gun form. Now, regarding that, just on face value, that seems like a reasonable claim. Those who were late paying their taxes because of serious addictions, but paid them back subsequently with interest and penalties, are typically given non-criminal resolution. Now, this is an interesting statement. When it comes to diversionary programs, they are given to people, usually first offenders, sometimes more, depending on the circumstances. It's often dependent on such extenuating circumstances for drugs or alcohol, but it's very specific to the crime. And that really needs a lot of justification to make that claim, especially since I can see it with the gun charges, but there's an entire separate set of federal tax charges which are placed and held against him. So, I think one of the questions that we need to ask is, does the crime committed deserve the diversion? And again, that's separate, one from the charges with the guns and one's for the federal tax evasion. So, the charges in his cases came about only after several of my political opponents in Congress instigated them to attack me and oppose my election. Then, a carefully negotiated plea deal agreed to by the Department of Justice unraveled in the courtroom. Now, a big question with that, since he's using that as an example of undue treatment, is why did it unravel? Was it justified, or is it just a statement? With a number of my political opponents in Congress taking credit for bringing political pressures on the process, he had the plea deal held, it would have been fair, reasonable resolution of Hunter's cases. Interesting. So, was the plea deal a just punishment? That is something we're going to have to look at. Now, no reasonable person who looks at the facts of Hunter's cases can reach any other conclusion than Hunter was singled out only because he is my son. We will see. We will see. And again, it implies unjust treatment of his son. Now, he says, and that is wrong. And the next step I have crossed out just because, and I will read it, but it's just a waste of words. It really gives no weight to his argument. This is for people who aren't going to consider the facts. There has been an effort to break Hunter, who has been 5.5 years sober, even in the face of unrelenting attacks and selective prosecution. In trying to break Hunter, they have tried to break me, and there's no reason to believe it will stop here. Enough is enough. Ooh, things are getting real. For my entire career, I have followed a single principle. Just tell the American people the truth. Interesting, says the politician. They'll be fair-minded, maybe a person, but not the people. Here's the truth. I believe in the justice system, but as I have wrestled with this, I also believe raw politics has infected this process and it led to a miscarriage of justice. And once I made this decision this weekend, there was no sense in delaying it further. I hope Americans will understand why a father and a president would come to this decision. And that is interesting. Very interesting. One, it's a contradictory statement. I mean, if he did respect it, he would let it play out, right? And then it's also a bad argument regarding the father portion, as every person in jail is a son or daughter of someone else, bro. Seriously. It just implies an emotive and legal reason, seeks empathy, in my opinion, first to cloud reason. Then we have his signature. And here we get to some good stuff. For those offenses against the United States which he has committed or may have committed or taken part in during the period from January 1st, 2014 through December 1st, 2024, including but not limited to all offenses charged or prosecuted, including any that have resulted in convictions by Special Counsel David C. Weiss. Don't know if that's pronounced right, but I'm going with it. In docket number 1:23-CR-00061-MN in the United States District Court for the District of Delaware, and docket number 2:23-CR-00599-MCS-1. Whoever came up with that coding system, they deserve a medal. In the United States District Court for the Central District of California. Now, one important thing to know here is why such a large time frame? I mean, most of these have come up somewhat recently, but we'll see. Another thing, usually the people's names who get noted in such press releases are for a reason. So we're going to take a look at who this individual David is. I believe he is the prosecutor, and he would be a source to determine if there is unjust treatment, since he is the one bringing the charges. Now, sorry, looking at comments. The things that we're going to look at, other than these docs that are noted in this document, are not only testimony, but transcripts and other primary sources, not news articles. Not news articles. So, one important note, just concluding this, is he never said he was innocent. Very interesting. Also, his primary claim is unjust treatment. Some subpoints to that it's based upon are this plea deal that Joe considered this a fair treatment, however it fell through, thus demonstrating that there is unjust treatment. Next, we need to consider if in this plea deal, since it was determined as just by Joe, was it a reasonable punishment? It did fall through. So we have to look at the gun charges, consider what is the normal punishment, and 2, the federal tax charges. What is the normal punishment for those as well? Who rejected it and why? Was there cause? Then we have the political reasons. This would imply there are biased parties. The noted prosecutor would be a good source to take a look at for that. And then just another interesting note to recap was the time frame. Very, very large, 2014 to 2024. And then we have the sources regarding the docket numbers for the court case. So we will move forward onto the docket regarding the gun charges next. Okay, I think I said the docket regarding the gun charges. I want to start off with the taxes. Now, this is a long document, but it's got a lot of good information in it. So, the plaintiff is the United States of America, the defendant, Robert Hunter Biden. And again, this is the document noted in the press release. First thing they note, literally in the first sentence, defendant Robert Hunter Biden. Hereafter, the defendant was a Georgetown and Yale educated lawyer, lobbyist, consultant, and business person, and beginning in April 2018, a resident of Los Angeles, California. Now, this is important, as it's difficult to plead ignorance to tax law when you're a lawyer. You probably know something about the law, and probably how to subvert some of it too. Next up, in point 2, the defendant served on the board of a Ukrainian industrial conglomerate and a Chinese private equity fund. Now, I consider that a different story, but interesting nonetheless. The time frame that comes up is curious. Again here, in addition to his business interests, the defendant was an employee of a multinational law firm working in an of counsel, quote-unquote, capacity from 2009 through at least 2017. In 2018, he stopped paying his outstanding and overdue taxes for tax year 2015. And there are many other notes regarding that. Here we move into more evidence and showing that he had the ability to pay. The defendant made millions of dollars in income from 2016 through 2020. Point 5, between 2016 and October 15, 2020, the defendant individually received more than $7 million in total gross income. This included in excess of $1.5 million in 2016, $2.3 million in 2017, $2.1 million in 2018, $1 million in 2019, and approximately $188,000 from January through October 15, 2020. In addition, from January through October 15, 2020, the defendant received approximately $1.2 million in financial support to fund his extravagant lifestyle. This is all important because it shows his ability to pay Why did he not pay if he had the ability to? Now, this goes into a little bit of the Ukrainian connection, the Burisma Holdings Limited. I just find it interesting given the time frame. In and around April 2014, the defendant joined the board of directors of Burisma Holdings Limited, a Ukrainian industrial conglomerate. Burisma agreed to pay the defendant an annual salary of approximately $1 million to be paid in monthly disbursements. In March 2017, Burisma reduced his compensation to approximately $500,000. What a pay cut. What a pay cut. But he continued to serve on the board of directors until in or around April 2019. So, again, this is kind of another story, but it's interesting. A lot of assumptions can be made regarding that connection and the time frame. So, now we're moving into where the defendant had a legal obligation to pay taxes on all his income, including income earned in Ukraine from his service on Burisma's board, fees generated by deal making with the Chinese private equity fund, as well as income derived from his work as a lawyer and other sources. Now, this is important. They make a note, including income earned in Ukraine. As you will see as things unfold, his business dealings from outside the country are interesting. Now, Forms 1040 and failed to timely pay. This shows that he made a lot of money. A lot. For example, his gross total income in 2016 was $1,580,000. The reported taxable income, $1,276,000, and the self-assessed tax due at the time of filing was $45,000. And that goes on to demonstrate as such. Next up, the defendant knew that he had to file and pay taxes. Because of his verified income streams and to facilitate the withholding and payments of taxes to the IRS, the defendant forms a Wasco PC, a C corporation, in or about 2006. This is interesting because, in my opinion, this is where it began, in 2006. And the formation of a company for the following. PC's sole purpose was to ensure that there were sufficient withholdings from all the streams of the defendant's income to pay his taxes. Instead of receiving income directly into his personal bank account, the defendant directed third parties to pay Owasco PC, which had its own bank account, any income owed to him. That is a structure. That is a structure, and it demonstrates intent. Another note demonstrating the structure. He could pay taxes if he owed anything beyond the withholdings made by Owasco. He had solutions set up to pay taxes. Another note, irrespective of the Owasco PC structure and his standalone tax account, quote unquote, he had done so for tax years 2014 and 2015, the 2 years preceding his scheme to not pay taxes. The defendant timely filed, after requesting an extension, his 2014 individual income tax returns on IRS Form 1040 on October 9, 2015. In my opinion, they are making such a point to show his ability to do so, as I believe the defendant was using his addiction as an excuse to not be held accountable for his actions. The defendant did not report his income from Burisma on his 2014 Form 1040. Another reason why this was probably back all the way to 2014. In my opinion, what he was doing with this is he was funneling the income through a foreign entity to try and get away with not paying taxes. Another point, the defendant timely filed after requesting an extension. If he can file extensions, he can file his taxes. Another, April 2017 to September 2017, a weekly quote-unquote bill update detailing his IRS liabilities and other outstanding bills. Therefore, if he was getting a weekly update, he was well aware of what he owed. Could you imagine that reminder every week? Jesus. All right. The defendant began to make periodic $10,000 payments to the IRS towards his outstanding 2015 liabilities. And then here is an interesting graph. The defense has definitely tried, to paint him as an addict and therefore not necessarily responsible for his actions. And there is literally quantitative evidence, I would argue, that he was definitely in a state of addiction. And this shows it. ATM cash withdrawals in 2016, 200,000, 2017, 503,000, and 2018 we go to $772,000. Quite a jump in 3 years. Definitely a progressive illness. 2018 was surely the height, or he just got better at hiding it. Another example there, in 2017, his adult entertainment fees were $56,846. That was up since 2016, which was only about $4,000 apparently. And then we hit a spike in 2018 going to $100,000. Things get expensive. So now, moving forward, point 39. In 2019 and early 2020, the defendant became embroiled in 2 civil lawsuits. These were not discussed much in the news, as far as I know. These lawsuits forced the defendant to file his outstanding tax returns for 2017 and 2018. Beginning in May 2019, Person 1 brought a paternity and child support action in Arkansas State Court against the defendant. And this is where things start to come out a bit. On or about February 18, 2020, the defendant late filed his 2017 Form 1040. On the 2017 Form 1040, the defendant reported $1,956,000 in taxable income and $581,000 in tax due and owing. Again, he's aware of it. And then he continued where he had a filing late in 2018. His taxable income for 2018 was $620,000. And he filed it again late. That is his 1040 form in February 2020 for 2018. Point G and underline. The defendant had the funds to pay his taxes in 2017, 2018, 2019, and 2020. Just to surmise everything that's happened thus far, is he has made multiple choices to knowingly evade. He chose not to pay them, notably in 2020, well after he had regained his sobriety, and when he finally filed his outstanding 2016, 2017, and 2018 forms 1040, the defendant did not direct any payments toward his tax liabilities for each of those years. It's interesting how they note his sobriety. Again, in my opinion, they're trying to make the point that whether he was high or not, it didn't make a difference. He just didn't want to pay his taxes. So, the important note is it demonstrates addiction had nothing to do with it. And that removes a lot of Joe's said excuse, at least for the unjust treatment. Now, we take a look specifically at what he is charged with. So, count 1. This is 26 USC 7203, failure to pay 2016 form. Now, from the source, law.cornell.edu, I would suggest is a good source for information on these. This is, be guilty of a misdemeanor, and upon conviction thereof shall be fined not more than $25,000 or $100,000 in the case of a corporation, or imprisoned not more than 1 year, or both, together with the costs of prosecution, according to the law.cornell. So, what follows all these are again further evidence that has already been described. I'm not going to repeat, but they're just a little bit more specific. There was one note in here, I didn't highlight it, but apparently at one point he tried to write off as, write off for his taxes, prostitution, which good on him for trying. Didn't really work out though. So again, we have another 26 USC 7203, failure to pay. We've already gone over that, but important thing to note that these things do add up. He's up to 2 years and a larger fine. We have another in count 3, failure to file in 2017. Then another count 4, failure to pay in 2018. And then count 5, failure to file in 2018, Form 1040. So we are up to 5 counts there, which is up to 5 years in prison, $125,000 personal, or $500,000 if they charge it with a corp. Here we have something different in count 6, 26 USC 7201, evasion of assessment for 2018 Form 1040. So I looked this up. Here was the definition. It is a felony crime. Any person who willfully, I can't read my note, but basically evades taxes imposed, or the payment thereof shall, in addition to other penalties provided by law, be guilty of a felony, and upon conviction thereof shall be fined not more than $100,000, $500,000 in the case of a corporation, or imprisoned not more than 5 years, or both, together with the cost of prosecution. I got that from Cornell. Next up, and more detailed information that you're willing to go and take a look at, but these are just specific examples. Enough examples to, as the court determined, declare him as guilty. Moving to the next. Okay. This is count 7. And this is a big one. 26 USC 7206, filing a false and fraudulent 2018 Form of 1040. Now, the requirements for this are very descriptive. 1. Declaration under penalties of perjury. Willfully makes and subscribes any return statement or other document which contains or is verified by a written declaration, that it is made under the penalties of perjury, and which he does not believe to be true and correct as to every material matter. Or 2, aid or assist, willfully aids or assists in, or procures, counsels, or advises the preparation or presentation under or in connection with any matter arising under the Internal Revenue laws of a return, affidavit, claim, or other document which is fraudulent or is false as to any material matter, whether or not such falsity or fraud is with the knowledge or consent of the person authorized or required to present such return, affidavit, claim, or document. Or 3, equivalent bonds, permits, and entries. Not too relevant. Or removal or concealment with intent to defraud. Removes, deposits, or conceals, or is concerned in removing, depositing, or concealing any goods or commodities for or in respect whereof any tax is or shall be imposed, or any property upon which levy is authorized by Section 6331 with intent to evade or defeat the assessment or collection of any tax imposed by this title, or comprises and closes agreements in connection with any compromise under Section 7122 or offer of such compromise, or in connection with any closing agreement or offer to enter into any such agreement willfully. And then there's a subpoint, concealment of property, and another, withholding, falsifying, and destroying records. That's always a good one. Let's read it. Receives, withholds, destroys, mutilates, good word, or falsifies any book, document, or record, or makes any false statement relating to the estate of financial condition of the taxpayer or other person liable in respect of the tax. In conclusion, they shall be guilty of a felony, and upon conviction thereof shall be fined not more than 100,000, 500,000 in the case of a corporation, or imprisoned not more than 3 years, or both, together with the cost of prosecution. Again, that's from Cornell. So that's 3 years right there. 7, we got another 7206, filing a false and fraudulent 2018 form at 1040. We got account 8, again, another 7206. Count 9, another 7203, failure to pay. And that is that. So again, we have another name come up, or the same name come up again. That's David Weiss. And he was the prosecutor. So now we will take a look at the gun charges and see what comes up. Okay. Now, an important note, the judge is, I'm doing my best here, is Norika. She's a U.S. District Judge. I did look her up a little bit, and her name did come up in the news a bit. Again, one of the claims that Joe Biden is making, and his son is making, and you'll hear about it here in these documents, is that he is unfairly and unjustly treated due to political reasons, and individuals are simply out to get him. So, to surmise these few things, defendant Robert Hunter Biden is charged with knowingly making a false written statement intended to deceive in connection with acquiring a firearm in violation of 18 U.S.C. 922 and 924. Knowingly making a false statement in connection with acquiring a firearm in violation of 18 U.S.C. 924 and possession of a firearm by a prohibited person in violation of 18 U.S.C. Presently before the court are defendant's motion to dismiss the indictment for selective and vindictive prosecution, with a related motion for discovery and an evidentiary hearing, as well as defendant's motion for issuance of subpoenas pursuant to Federal Rule of Criminal Procedure, for the reasons set forth below. And I think it's time to get a wired mouse. So they go into a description. Long story short, regarding these charges with a gun, simply, he bought a gun when he was high. He lied on the document that he was high. He decided 11 days later, probably when he was still high, to get rid of the gun, threw it in a trash can. The police found it. They didn't consider it a big enough deal to file any charges, and it just kind of went away. So, one of the first notes in here, in October 2018, during a time when defendant was struggling with addiction, and I only bring this up because the other documents in the prior case do corroborate this. So, next, the parties attempted to resolve these charges with a plea agreement on the tax offenses and pretrial diversion on the firearm offense. As detailed in an earlier opinion, those efforts were unsuccessful after negotiations fell apart when it became clear that the parties had fundamentally different understandings of the scope of immunity conferred by their agreements. This I find interesting. Very interesting. We move on to... One second. The documents and information bearing on the question of whether the investigation or prosecution of defendant was based on pressure from any executive branch official or other outside influences. Defendant seeks to dismiss the indictment on the basis that his prosecution is selective and vindictive and violates the separation of powers. That is a big claim. A really big claim. And they go into it. Selective and vindictive prosecution. I mean, this is basically saying that the executive branch and the legislative branch have it out for him. So, to summarize, a claim of selective prosecution is defined as an independent assertion that the prosecutor has brought the charge for reasons forbidden by the Constitution. Now, the prosecutor in this case is David, and that's important, as you'll see. And a side note on that, David was originally brought to power by Trump. Biden got into office. Biden kept him there. So I'm assuming that he's competent. The defendant bears the burden of showing that persons similarly situated have not been prosecuted for the same offense to satisfy the discriminatory effect element. That is difficult. Another difficult claim to make. One form of selective prosecution is vindictive prosecution. There are two ways in which a defendant may demonstrate vindictive prosecution. First, a defendant may use evidence of a prosecutor's retaliatory motive to prove actual vindictiveness. And second, in certain circumstances, a defendant may show facts sufficient to give rise to a presumption of vindictiveness. Now, one of the hard things about proving such things is you can bring up stats all you want, but it doesn't mean that you don't deserve to be in the category that doesn't support, your claim. In other words, and they'll use this as an example, 1.8% of whatever are convicted and the rest are not, well, why doesn't it justify, in his case, to be part of that 1.8%? You'd have to prove it. Second, discovery and support of selective or vindictive prosecution. Again, they note that not only is the standard for showing selective prosecution a rigorous one, but so is the standard for obtaining discovery in support of such a claim. And they go into a lot of detail on that. I'm going to skip to the discussion as it usually wraps everything up. Yet, as defendant explains in reply, his selective and vindictive prosecution claims are focused on the prosecution's decision to abandon the plea and diversion agreement framework it had signed in response to ever-mounting criticism and to instead bring this felony indictment. So, this is important as the argument is based on the plea deal, not the administration or the prosecutor specifically. So, moreover, the only charges at issue in this case are firearm charges. Defendant's financial affairs or tax-related charges or investigations thereof also appear irrelevant. Thus, the only charging decision the court must view through the selective and vindictive prosecution lens is special counsel David Wise' decision to no longer pursue pretrial diversion and instead indict defendant on 3 felony firearm charges. Now, again, Biden kept David appointed after Trump's administration had ended. And after reading the transcript of a case where he is speaking, he is very competent, in my opinion. This goes into the selective prosecution. Defendant argues that he has been selectively charged for an improper political purpose because he is the son of the sitting president, the latter of whom is a candidate in the upcoming presidential election. Quote, this case exists because Mr. Biden is politically affiliated with his father, the sitting president, and a candidate for re-election at a time when a historically divided nation prepares for a contentious presidential election. End quote. Open quote. Mr. Biden is being targeted because he is the son of a sitting Democratic president and a political rival of former President Trump, who seeks to defeat President Biden in the upcoming presidential election. Close quote. And they determined that defendant has failed to show either, which I would agree, since it would have to be shown to be by David, which they are not trying to prove, but they keep on bringing up Trump. Here they move into the discriminatory effect. So the defendant must show with quote-unquote clear evidence that similarly situated persons have not been prosecuted. Quote, a similarly situated offender is one outside the protected class who has committed roughly the same crime under roughly the same circumstances, but against whom the law has not been enforced. Close quote. Protected classes are specific, and here they give an example. The protected class comprised of individuals of a certain race or nationality. This is difficult, being the fact that, he's a middle-aged white male. Defendant never argues that he is being selectively prosecuted because he is a member of any specific political party or because he engaged in any specific political activity. Instead, he claims that his prosecution is unconstitutionally selective because he is being targeted politically and because he is politically affiliated with his father. Thus, defendant's articulated protected class is apparently family members of politically important persons. The argument is ridiculous. The amount of pages of evidence, the timeline, which is so important to prove intention, is so detailed. Next, the defendant claims that several experienced legal experts and law enforcement officials agree with the special counsel's initial decision to not pursue charges, again citing a news article. The one thing I'm trying to stay away from in this discussion. And I think that they make a point of noting that. And here's the citation. To the extent that defendant's claims that he is being selectively prosecuted rests solely on him being the son of a sitting president, that claim is believed by the facts. The executive branch that charged defendant is headed by that sitting president, defendant's father. The attorney general heading the DOJ was appointed by and reports to defendant's father, and that attorney general appointed to the special counsel who made the charging decision in this case while defendant's father was still sitting president. Defendant's claim is effectively that his own father targeted him for being his son, a claim that is nonsensical under the facts here, regardless of whether congressional Republicans attempted to influence the executive branch. There is no evidence that they were successful in doing so. And in any event, the executive branch prosecuting defendant was at all relevant times, and still is, headed by defendant's father. So I misspoke. One, that wasn't the citation to the news article. That's citation number 3. There is a little bit of discussion, it seems, in my opinion, that the gun charges were used just as like a fishing expedition, which they may be, but it doesn't mean that they're illegitimate charges. And then here's the example that he uses. That goes to my argument that there's no reason why he should not be part of the 1.8%. He does mention that defendant attempts to show the discriminatory effect element by arguing that just 1.8% of the 132,464 federal firearm prosecutions between 2008 and 2017 were for persons unlawfully using or addicted to controlled substances within the meaning of Section 922G3. They go on to say, even if national statistics could suffice as clear evidence to warrant dismissal on the basis of selective prosecution, the statistics cited by defendant are nevertheless deficient because they say nothing about the individuals who have been prosecuted between 2008 and 2017. Very true. At best, the defendant has offered national statistics regarding how often the government prosecutes firearm charges against persons unlawfully using or addicted to controlled substances in general. That's hilarious. They're basically just saying, thanks for telling us. One second. Now, this falls under discriminatory purposes. The defendant contends that the arbitrary factor driving the prosecution here is his affiliation with his politically active father. All I'm thinking is he is not political, Hunter, in my opinion. To satisfy this second element, then, defendant needs to show with clear evidence that the decision to prosecute him was because he is the family member of a politically important person. In the present case, petitioner has not shown that the government prosecuted him because of his protest activities. Absent such a showing, his claim of selective prosecution fails. I love these conversations. People put so much thought and effort into constructing these sentences and conversations. If only our conversations that we had face to face were of such relevance, and content, and value. Defendant contends that the discriminatory purpose behind his prosecution is targeted based on, quote, his political affiliations and as a proxy for the political affiliations of his father, end quote. Defendant points to past and recent statements made by former President Trump alleged conduct of one of the former president's personal attorneys, Rudy Giuliani, and a purported criticism and pressure campaign by congressional Republicans. Now, honestly, on a side note, who is going to take anything Trump says seriously? I mean, the things that come out of his mouth are crazy. If people took them literally, I mean, who knows what would happen? The court has been given nothing credible to suggest that the conduct of those lawmakers or anyone else had any impact whatsoever on the special counsel. It is all speculation, and I would agree. The defendant then claims that the DOJ's efforts, that's the Department of Justice, to torpedo the original plea deal in response to political blowback puts the matter to rest. According to defendant, the abrupt change in course from proceeding with pretrial resolution of the tax and firearm charges to pursuing indictments in both cases evidences a 180-degree about-face in response to congressional IRE and criticism that can be interpreted as an improper motive. The problem with the defendant's argument, however, is that he offers nothing concrete to support a conclusion that any member of Congress or anyone else probably just picked up a news article. Again, opinion. Nothing but opinion. This falls under vindictive prosecution. As to actual vindictiveness, defendant does not accuse the prosecutor here, Special Counsel Wise, of harboring any actual animus towards him. Now, this is really important, as so much of the before defined properties of said allegations that must be held, it relies on the prosecutor. So, again, the defendant does not accuse the prosecutor here, Special Counsel Wise, of harboring any actual animus towards him. Instead, defendant makes claims of animus by a number of other individuals, the former president, his supporters, and the other opponents of the Bidens. This removes the intent from David. A relevant point in time is when the prosecutor decided to no longer pursue pretrial diversion and instead indict defendant. Interesting. Basically, they're making the argument that the plea deal fell through due to outside pressure and not without cause, which we will look at the transcript, which, not to jump the gun, but I love the judge's attitude. The defendant fails to identify any right that he was lawfully exercising that prompted the government to retaliate. Another, regarding the separation of powers argument, defendant argues that his prosecution also violates the separation of powers. It's crazy. It's dumb, and it's treated as such as, and I'll quote, the gist. I wonder if that's the first time the word gist has ever been used in a legal document. Ever. I'd be willing to say so. The gist of the defendant's argument is that the legislative branch has failed to respect the prosecutorial discretion vested in the executive branch and instead attempted to usurp that authority. He goes so far as to assert that these legislative branch officials, quote, have overcome Special Counsel Wise's independent judgment, close quote, and even further, those officials are the reason that pretrial diversion was abandoned in favor of indictment. We will see. Defendant's separation of powers argument is not credible. I mean, check this out. And defendant does not actually accuse the legislative branch of successfully encroaching on or usurping the executive branch's power. Special counsel purportedly causing him to make charging decisions that he would not otherwise make simply because members of Congress are unhappy. I highly doubt that. Highly doubt it. As the court has explained several times herein, defendant has failed to offer anything credible to suggest that the special counsel's decision to abandon pretrial diversion and pursue indictment was actually influenced by any member of Congress or anyone else. And under the defendant's motion for issuance of rule subpoenas, and this is really interesting, basically says he should be able to subpoena Trump, William P. Barr, Richard Donahue, and Jeffrey A. Rosen under Rule 17C. Under Rule 17C, it allows a party to obtain from a witness before trial documents and other evidentiary materials that may be used at a trial. In my opinion, some of this stuff is just trying to get evidence thrown out. The time period covered by the subpoena is vast, January 2017 to present. The defendant argues that the requested documents, quote, may be used either in pretrial pleadings or in pretrial evidentiary hearings on his motions to dismiss the indictment. And this I thought was important. First, as the government points out, defendant was not charged with the current or any firearm offenses while any of the 4 individuals held office. There it is. The decision to prosecute defendant was made by and during the current administration, one headed by defendant's father and an attorney general appointed by and serving at the pleasure of defendant's father. And it does sound like they have a good relationship. I didn't see anything where they're, straight up trash talking each other. So, the conclusion: for the foregoing reasons, defendant's motions to dismiss the indictment for selective and vindictive prosecutions, for discovery of an evidentiary hearing, and for issuance of Rule 17c subpoenas are denied, all caps, just so you can remember it. Good stuff. Okay. I'm going to put this on pause for a second and get up the next document. Okay, we are back. Now, this document, this is a transcription of the trial that they had regarding the plea. So, in essence, within this, it should demonstrate why it was thrown out, right? So that's why we're looking at it, is to see if there was just cause. To kind of, I won't give my opinion first. We'll wait. Even though you can read it up at the top. So I really like the voice of this judge, how it comes out. I'm going to have to get a little closer. So, from the court, when I say the court, that's the judge. Clark is his attorney. Wise, that's representing the feds, the Justice Department. So says the court. All right, thank you. Okay, so we do have 2 cases here. One is a criminal action based on a felony information related to a gun charge, and the other is criminal action 23-274 based on the misdemeanor involving the tax charges. And I am kind of scrolling through this just to get important points regarding if it's just or not. And you must participate in a program. So they're talking about the diversionary program that was part of this plea deal, which is pretty much the entire plea deal. And you must participate in a program of inpatient or outpatient substance abuse therapy or counseling if directed by the pretrial services officer or the supervising officer. Do you understand those conditions? The defendant, yes, Your Honor. And it goes on to the court saying, now, again, we have two cases and two agreements. And I understand that the diversion agreement is not something that is typical before the court, but you all did send it to me. So I do want to talk about that a little bit. There are some provisions in those agreements that are not standard and are different from what I normally see. So I think we need to walk through these documents and get some understanding of what is being proposed so that I can give due consideration to the determination that you all are asking me to make. So I want to start with Criminal Action 23-274 involving the tax charges. All right. Now, Mr. Biden, you told me that you intend to enter a plea of guilty in those cases, correct? The defendant? Yes, Your Honor. The court. So it is my responsibility to make sure that the plea is a voluntary and knowing plea. And in order to do that, I first need to ask you a series of questions. Before I ask you those questions, I'm going to have you placed under oath to answer those questions truthfully. And it's important that you do answer those questions truthfully, because if you don't, any false answers may be used against you in a separate prosecution for perjury. Do you understand that? They go on to go through that process. Ask about his mental state, all that kind of stuff. The court asks, so I need you to tell me about that. How many times have you, to the best of your recollection, been treated in inpatient or outpatient? The defendant, beginning in 2003 with the inpatient, Your Honor, I have been to, I believe, close to 6 inpatients over the course of 20 years. He has definitely had a struggle. With that, I empathize. Here's another point. The court, well, let's just be clear because, people might look at this transcript. I said, is that correct, what you said to me? The defendant, I'm sorry. Yes, Your Honor, excuse me. The court, and sir, do you understand what's going on and why you're here today? The defendant, yes, I do. The court, counsel, do you have any doubt as to your client's competence? Mr. Clark, none whatsoever. Okay. Another note. And here, they're talking about the details of the plea agreement. In paragraph C, it provides that provided that the United States does not subsequently learn of conduct by the defendant inconsistent with the acceptance of responsibility, that it will not oppose a 2-level decrease pursuant to U.S. sentencing guidelines. So I looked into this a little bit, and what they mean by a 2-level decrease is they have a point system, and based on that point system, what you score will determine your judgment. Basically, the severity. As long as they don't find out, basically. They discuss evidence in the future case. The court. All right. In Exhibit 1, there are references to taxes paid by a third party on Mr. Biden's behalf of $955,800 and $956,632, as well as $492,000 in 2016 and $197,000 for 2019. Just looking at 2017 and 2018, which we are subject of this case, those numbers add up to more than $1.9 million. Can you help me square that with the relevant conduct? Mr. Wise. So the amount that was paid by the third party includes significant penalties and interest, which we have not included, in the law stipulation that's in paragraph 5A. Interesting. Paragraph 15 of the diversion agreement states that the United States agrees not to criminally prosecute Biden outside of the terms of this agreement for any federal crimes encompassed by the attached statement of facts, attachment A to the diversion agreement, and the statement of facts attached to Exhibit 1 to the memorandum of plea agreement, filed this same day. This agreement does not provide any protection against prosecution for any future conduct by Biden or by any of his affiliated businesses. And just so we are clear, this is from the court, I think you already answered this, sir, but are you relying on that promise in connection with your agreement to accept the memorandum of plea agreement and plead guilty? So basically what's coming up is, are you just pleading guilty in order to get out of those 2 tax charges? Right? And here we go into that. The court. All right. So I need some help here because you all told me this was a plea under Rule 11 and not C1A. But yet I have this provision that I would think is normally in a plea agreement. So tell me, how do these agreements relate? And are they part of a package deal? Mr. Wise, so, Your Honor, the United States position is that the agreements stand alone by their own terms, and both agreements include their last paragraph that says, with this one caveat, gotta love that. And then there's an M dash, and it splits to the court. This is a big caveat, though, if you are telling me Rule 11 doesn't give me any authority to look at this, C1A refers to, having an agreement not to prosecute. That's why I'm looking at this. I'm not saying that you are wrong, but I need to understand this. Mr. Wise? Sure. So, Your Honor, again, our view is the plea agreement stands alone. There is no charge bargaining in the plea agreement, period. And that's what they have agreed to, the diversion agreement. The court? But he would not argue, just so I understand, sir. You would not argue to that plea agreement if you didn't get some immunity from other charges. Is that right? Mr. Clark, speaking for my client, that's correct, Your Honor. And that's it. That is it. The court, do you guys need to talk about this for a few minutes? Love it. Love it. Mr. Clark, yes. The court, how about I give you guys an opportunity so we can make sure we are on the same page, because part of my charge here is to make sure that the defendant knows what he's pleading to. I feel like they're on the same page. I think they all get it. Mr. Clark, we appreciate it. Your Honor, court clerk, all rise. They recess. The court, all right, please be seated. They come back. Moving forward a little bit. The court, so you are not answering my question. You are saying, well, we think it's valid and enforceable. I'm asking you, if it were not, go with me here, if that agreement were not valid and enforceable, if that agreement did not exist and he could not rely on it, would he enter the memorandums of plea? Mr. Clark, you are asking for a hypothetical from me. Your Honor, the court, yes, I'm asking that because, Mr. Clark interrupts, yes, my client would resolve this case on these terms in the hypothetical situation that exists without the diversion agreement. I want to be clear that it is the parties' position that there is a diversion agreement between the parties which is binding. But take that out of today's proceedings and my client is ready to enter a plea under the plea agreement. Work with me, mouse. The court. So, have you ever seen, I think I just asked you this, but have you ever seen a diversion agreement where the agreement not to prosecute is so broad that it encompasses crimes in a different case? Mr. Wise? No. And I would say, Your Honor, I don't think it is broad in the sense that she cuts him off. The court, we are going to talk about that. You can sit down. Love it. All right. Now, is an agreement not to bring charges or an agreement to drop charges typically something that is included in a memorandum of plea agreement? They can make a movie out of the scene. The court, in your view, that would change the analysis of what I needed to do in evaluating whether to accept this plea or not, right, Mr. Wise? It would, the court. And so let's just understand this. If it were that, then my role would be to accept or reject this plea, right? Mr. Wise, it would. The court. What happens if I accept the plea? We go forward to sentencing? Mr. Wise, yes. The court. And what happens if I reject the plea? Mr. Wise, then this is one of the issues with charge bargaining. Again, it's just, there's so much mud. The court, so I don't mean to violate the separation of powers or do anything unconstitutional. I'm trying to figure out what my role is and what the appropriate rule is that applies to this. Next point, the court. Okay, so you can sit down. I think what I'm concerned about here is that you seem to be asking for the inclusion of the court in this agreement. Yet, you're telling me that I don't have any role in it, and you are leaving provisions of the plea agreement out and putting them into an agreement that you are not asking me to sign off on. So I need you to help me understand why this isn't in the written plea agreement. Another little note. It says, this is by the court, that it should not have come as a surprise. It wasn't surprise, is that right? The defendant, yes, Your Honor. The court, and you knew? The defendant, well, I didn't write this, Your Honor. So the characterization, Mr. Clark cuts in, can we elaborate the time there, Your Honor? Court, yes. So this is regarding some of his known liabilities. And I think that wraps it up. So the whole purpose of that was to see if the removal, let me read this last part. So at this point, I'm just going to ask you, without the plea agreement, this is from the judge, without me saying that I would agree to the plea agreement, how do you plead to the charges that we have been discussing? The defendant, not guilty, Your Honor. The court, thank you. So, again, to wrap that up, basically, it's just seeing if there were, if the plea agreement was legitimate or not. If there was cause to not accept the plea agreement, to remiss it, then the claims are null and void. So, one last thing I want to do is I want to look up some stats real quick. Hold on. So, another thing that I thought was important to consider in coming to a decision with all this is to look at how often people are actually charged. And under these, and by charge, I'm talking about, the tax fraud, and what is like the average time they would spend in jail. I mean, basically looking if the plea agreement, for example, something that it stated, if that was a just punishment or not. In other words, if you would have accepted it under those charges, would that be fair? And then, would it be fair for him to be pardoned as well? So let's take a look. What this is what percentage of federal tax offenders were sentenced to regarding prison in 2019. The following statistical information is sourced directly from the United States Sentencing Commission, USSC. You can view the brief report in entirety by clicking here. Blah, blah, blah. Who most frequently commits tax crimes and where? A total of 494 individuals were convicted of tax fraud. Convictions have decreased since 2015, when 660 individuals were convicted. So, this is important because there's not that many people that are convicted. But one thing to consider is how many people were brought onto charges. Statistically speaking, and in this case true, the typical tax offender is a white, male, U.S. citizen at an average age of 50 upon sentencing. I think they just about hit that on the nail of the head. Now, here we go into the penalties. In general, penalty enhancements were more common than penalty reductions. For example, penalties were increased for offenders who A. led or supervised the offense, B. obstructed justice or otherwise impeded the investigation or case, C. used sophisticated means to hide or carry out the offense, and lastly, used a special skill or abused a public position of trust. Now, I do feel that that is pertinent since he did have skill in the law and setting up companies, corporations, and other ways to facilitate the movement of money. I think he would not fall under the reduction class. By comparison, only 3.9% of offenders received sentence reductions, which were permitted in cases where the defendant was considered a minor or minimal participant in the offense. And then here's a big one. The majority of those sentenced, a total of 65%, that's over 50%, received prison sentences. Though alternate sentences were not specified in the report, IRS crime statistics, which are linked below for further reading, note that the term sentence may, in place of or addition to incarceration in federal prison, including confinement to halfway houses, home detention, or some combination thereof. In other words, convicted offenders may be placed under house arrest or be ordered to live in specific environments, even if they are not necessarily incarcerated in prison. And here it is. The average length of a prison sentence for tax fraud was 16 months, or 1 year and 4 months. So, this isn't talking about whether it's a single case. In other words, like you broke this one rule, that's what you're going to get, or a conglomeration of them. But nonetheless, whether it is or not, over a year for tax fraud in jail, and over 50% receive prison sentences. And with the amount of evidence that was against him, the crazy amount of evidence, he would have gotten something. And he earned it, in my opinion. I mean, he went for it. And he got it. And he got off. So let's take a look at Biden's original claims. So, primary claim, the unfair treatment. And the sub, the punishment that does not suit the crime. The unjust treatment, all of his claims that were noted under the gun charges were completely null and void. And I think it was demonstrated as such in the evidence provided, and also just using common sense after reviewing it. Now, the punishment does not suit the crime. So, regarding the gun charges, the diversionary measures seems legitimate. Like, I can totally get behind that. Hey, you made a mistake. It's nothing serious. But with the federal tax crimes, that is a whole nother deal. Again, over 50% were convicted, right? And of that, spent at least a year in some form of imprisonment. And he's not going to have to serve a day. And regarding the claim of whether the plea deal was equal to the punishment, one, I consider that was a manipulative tactic to try and get away with something. And two, no, it should have been rescinded because it was not fair. They were bringing two court cases together and then trying to get rid of federal tax charges and avoid them at the same time. So, the claim is null. There is nothing there at all. The gun charges, I'll go with it. Federal tax charges, no. So much of that statement was emotional. So much of it. I mean, really, out of all the paragraphs, I think there were like 4 or 5, 2 were the only ones that held really any content. The rest were emotive and giving excuses, emotional excuses without justification after looking at this for Joe Biden's action for excusing Hunter Biden's actions. And that demonstrates that Hunter Biden should not have been pardoned by Joe Biden. And Joe Biden should have followed through with one of his claims that was in this document about trusting the judicial system. Because apparently he doesn't respect it. And I see why in this case, because if he did, his kid would be in jail, most likely. So, interesting story and I enjoyed looking into it. I hope someone out there will get something out of this information. I hope they perceive it as good information, because if I give any, if it's not a joke, I want it to be taken seriously. So, thank you for listening. Have a great night.